Hello, I'm Dave Woolley. Welcome to another episode of 10 Minutes Land Surveyor. Today I'm going to be talking about standard of care. Now understand that standard of care is a very broad issue. I've taught 8-hour days on standard of care. I've taught 8-week classes on standard of care. Standard of care is an objective test that is applied to professionals to determine negligence, and it's usually determined by the testimony of experts. And I have served as such an expert in many instances. Because it's such a broad topic, and because we have only 10 minutes to discuss standard of care, I'm going to address an issue on this, and this will probably turn into a series of episodes on standard of care. But the one thing I want to address today is locality. So when you are looking at negligence, the standard of care is there's a duty, there's a breach of the duty, and then there's a component of that is a geographical locality. And essentially what it means is that would you do what a reasonably prudent, knowledgeable person would do in that locality? And what's interesting about this is people think, well, you know, I'm a crappy surveyor, but everybody around me is equally crappy, so our standard of care is crap. That's not how it works. And I have some case citations, and that's kind of what I want to talk about. Broadly, and I don't want to spoiler alert here, but locality in our instance as a profession is very similar to the attorneys as opposed to the doctors. Doctors, they have a locality component to what they do, and that being that a small town with 2 doctors won't have the facilities to that maybe a large metropolitan area would have, like a UCLA, as opposed to a 250-person town with a 1-horse doctor. And so locality does apply to the medical profession, but when you go through the court cases, that's generally true with the medical profession. It is not true with the attorneys, the engineers, and the surveyors. So I'm going to walk you through this. So let's look at the screen. What we have here is a standard of care is actually your defense. You're going to argue that you met the standard of care, therefore you're not negligent. And this is an important way to understand this. And the standard of care is not perfection. That's also important to understand. But as it says on the screen, the standard of care is an essential concept in determining whether a person is negligent or potentially liable for a tort. If the person breaches that standard and applies to them, their actions cause harm to another person, they'll be liable for the negligence. There's a lot to unpack there. We're focused on locality today. On the screen here, you see the reference to a case that was actually in the Wyoming Supreme Court from 1970. But when I researched this same case had been cited in several other states, and I chose this case. It's generally the same as others, but I like some of the phrasing that they used. So we'll start here and read the first sentence. It says, professional men in general and those who undertake any work calling for special skill are required not only to exercise reasonable care in what they do, but also to possess a standard minimum of special knowledge and ability. Unless he represents that he has greater or less skill or knowledge, one who undertakes to render services in the practice or of a profession or trade is required to exercise the skill and knowledge normally possessed by members of the profession or trade in good standings in similar communities. And if you can see the screen, I'll read it to you briefly, but if you can see the screen, it says, type of community. Allowance must be made also for the type of community in which the actor carries his practice. A country doctor cannot be expected to have the equipment, facilities, experience, and knowledge or opportunity to obtain it afforded him by a large city. The standard is not, however, that of a particular locality. If there are only 3 physicians in a small town and all 3 are highly incompetent, they cannot be permitted to set a standard utterly inferior to the 4th who comes into town. That is what we're talking about today. So again, just because you and your pals can take any 2 monuments in a county and establish any boundary in that county, that does not mean it's the standard of care. because you have to understand that boundaries are established by state law, with the exception of federal lands, and state law governs. If you look at the California Civil Procedures, when you have conflicting elements in a deed, Section 2077 lays that out. We all understand proration. We all understand senior rights. These aren't qualities or knowledge that is specific to Bakersfield or Humboldt or San Diego. These principles apply equally because they're instituted by state law, either statute or case. Therefore, locality doesn't apply. And I've heard a number of surveyors say over the years, well, you know, the standard of practice in Northern California is different than Southern California. Well, no, the standard of care, the standard of practice is no different. It's the same. It's just whether the locals choose to practice that way. It is commonly made in the cases of physicians or surgeons because of the difference in the medical skill commonly found in different parts of the United States or in different types of communities. In other professions, such as that of an attorney, such variations either do not exist or are not significant, and allowance for them has seldom been made. A particular profession may be so uniform in different localities as to the skill and knowledge of the members that the court will not feel required to instruct the jury that it must make such an allowance. And that right there says it all. Just because your local practice is in the basement doesn't mean that that's the standard of care in your region. And so do not make the mistake of following bad practitioners in your area. If you have folks that take two monuments, survey halfway across the county, put a boundary in, and then you have a county surveyor that'll file that map, that is not the standard of care. And if your number gets pulled and they bring in an expert, are you going to have other experts that are going to say, oh yeah, that's straight out of Brown, or that's straight out of Clark, or that's straight out of Waddles? No way in a million years, because those particular type of practitioners will not show up in court. If they did, they may not pass the court may not accept them. So to close this video out, here's what I'm going to tell you is do not rely on locality as your defense. If you breach the standard of care, which means you were negligent, do not figure that locally that's how work is done or that's how I'm going to do it. If you say found mon and that's your monument description, and then you look at the Business and Professions Code, section 8764A, and it says like, kind, and any other pertinent information when describing a monument, found mon, by definition is negligence per se. You're in violation of the statute, and you've surrendered your defense. So do not rely on local practice, local bad practice as your defense, because you will not survive a negligence case. And in closing, I'll tell you this, the Board of Professional Engineers and Land Surveyors in California doesn't determine the standard of care themselves, although I've seen them stretch out and offer to do so. It's generally not what they do. They determine whether you violated a statute, and if you violated a statute, then you're negligent per se. Necessarily, they have to stretch out and thread the needle in some of these cases, but I don't think they're going to give you a break because they're a statewide jurisdiction. If you're doing really bad practice in some backwater, they're gonna hold you to the same standard as if you're in a county with many other surveyors, and that's the only way it should be. So I'm going to tell you this: pack away your clown shoes, put away your mini bikes, and do not rely on locality as your defense for standard of care. Thank you and have a nice day.